Hello and welcome to the third video in a series focusing on contract law in England and Wales. In this video, we will be looking into the second element of the formation of a valid contract, the acceptance of an offer.
By the end of this video, you should hopefully be able to define the valid acceptance of an offer, understand the requirements of acceptance and communication of acceptance, understand the effect of counteroffers, and also recognise the necessity of certainty of contract. So firstly, what is acceptance? Well, in the law of contract, Tritle provides the following definition. An acceptance is an unqualified expression of assent by the offeree to the terms of the offer. Therefore, acceptance must be unequivocal and unconditional, and the acceptance must be communicated to the offeror. A contract will only be capable of enforcement if an offer is accepted and an agreement reached between the parties. Whilst it may seem obvious in some cases that acceptance has occurred, parties often become involved in disputes as to whether a response to an offer constitutes an acceptance or not. To determine whether acceptance is valid, we need to consider the following: the communication of acceptance, the terms of acceptance, and the certainty of acceptance. Firstly, we will look at the communication of acceptance. The general rule is that the offeror must receive the acceptance before it is effective, as seen in the case of Torres and Miles Far East. In most circumstances, an offer will be accepted expressly or by written or spoken words. However, it is also possible that the conduct of the parties may constitute acceptance, as seen in the case of Brogden and Metropolitan Railway Company. This was further confirmed in Hillis & Co. Limited and Arcos, where the court held that it is possible to infer an intention that the parties consider themselves to be bound by looking at their conduct. However, in the case of Scammell and Nephew Limited and Austin, the courts took the view that there must be certainty as to the terms of the agreement, and that the courts should not be speculative on an agreement where the parties are still in negotiations, as this is not a completed agreement. Furthermore, silence will generally not suffice as acceptance, as discussed in Feldhaus and Bindley. On the other hand, there are some scenarios in which the need for communication may be waived. An example of this would be where a party's conduct or performance fulfills the terms of the contract. This is most common where unilateral offers have been made. In such cases, communication of acceptance is not required, as there is an implication that there has been a waiver of the requirement of communication. This was considered in the case of Carlyle and the Carbolic Smokeball Company, as discussed in the previous lecture in this series. There is a presumption that an acceptance will come back in the same form as an offer. Where a preferred mode of communication is not given, the form of communication will depend on the offer itself and the surrounding circumstances. In some situations, there may be a prescribed mode of communication by which acceptance is to be made, and in such cases, clear wording is required if the method of communication is to be mandatory, as seen in Yates Building Co. and R.J. Purlane. Where a method is prescribed, generally any method of acceptance which is equally effective will suffice. This being said, in certain scenarios a specific mode of acceptance may be deemed inappropriate, as discussed in Tin and Hoffman and Co. Where it is agreed that the parties will use the post as a means of communication, the postal rule will apply. The postal rule states that where a letter is properly addressed and stamped, the acceptance takes place when the letter is placed in the postbox and not when it is received by the person making the offer. This rule was established in the case of Adams and Lindsell. It must be reasonable to have used the post, or the postal rule will not apply. The courts are often willing to disapply this rule, however, and it has been regarded as out of date. It is also relatively easy for the parties to a contract to exclude the postal rule by specifying that the offeror must be aware of the acceptance, as found in Holwell Securities and Hughes. Nowadays, many contracts are created and entered into using the internet or instantaneous forms of communication. The postal rule does not apply to the acceptance of these contracts, and instead, acceptance occurs when the communication is received, as discussed in N. Torres and Miles Far East. There is an assumption that a message of acceptance sent during normal business hours by means of instantaneous communication can be reasonably expected to have been received, as found in Brinkebon and Stahag Stahl. However, if acceptance is received outside of office hours, acceptance is assumed to take place at the beginning of the next working day, as discussed in Mondial Shipping and Astart Shipping Limited. Secondly, we need to consider the terms of acceptance. For acceptance of an offer to be valid, an offeree must unreservedly assent to the terms of the offer. Adding, removing, or differing the terms of the original offer will amount to a counter-offer, and no contract will therefore exist. Furthermore, a counter-offer has the effect of destroying the original offer, which cannot be accepted at a future time as established in Hyde and Wrench. It is important to note that if an offeror makes a significantly different offer to the same offeree, this implies withdrawal of the first offer, as seen in Pickfords Limited and Celestica Limited. Distinguishing between a counter-offer and acceptance can sometimes be difficult, and it is also important to note that a request for more information in relation to a particular offer does not destroy the original offer in all cases, as discussed in Stevenson and McLean. A battle of the forms arises where two parties enter into negotiations with the intention of entering into a contract, but each party attempts to conclude the contract on their own standard terms and conditions. In such situations, it is necessary to identify which party's terms and conditions have been agreed and incorporated into the contract. In the case of Butler Machine Tool Co. Limited and Excello Corporation Limited, it was determined that where there is a battle of the forms, whereby each party submits their own terms, the last shot rule generally applies, whereby a contract is concluded on the terms submitted by the party who was the last to communicate those terms before performance of the contract commences. This was considered in the later judgment of Tech Data Interconnection Limited and Amphenol Limited, in which it was ruled that where documents and intention of parties suggest that some other terms are to prevail, the last shot approach may be displaced. The recent High Court decision of TRW Limited and Panasonic Industry Europe GmbH and another company has added further dimensions to this last shot approach. In this case, it was held that the first shot had won, as the buyer in the case had agreed to the seller's standard terms at the outset, which precluded any contrary terms proposed by the buyer from applying. It is also important that there is a minimal degree of certainty in any contract. When viewed objectively, it must be possible to determine exactly what the parties have agreed to. Otherwise, the courts may refuse to enforce a contract due to uncertainty, as seen in Guthing and Lynn. In Scammell and Ouston, the parties had agreed to the supply of a lorry on hire purchase terms. The House of Lords held that in the absence of any other evidence of the details of the hire purchase agreement, this was too vague to be enforceable, and there was therefore no contract. This does not necessarily mean that all details of a contract must be finally settled in advance, however, and in some contracts, something as fundamental as the price might not have been agreed, but if it is to be fixed based on some future condition, then it may be judged to be sufficiently certain, as seen in Shell Limited and Lostock Garage Limited. Furthermore, it is not uncommon for supply of services contracts to leave the amount to be paid unspecified at the time of agreement. This approach now has statutory force by virtue of Section 15 of the Supply of Goods and Services Act 1982, which states the following: where the consideration for a service is not determined by the contract, left to be determined in a manner agreed by the contract or determined by the course of dealing between the parties, there is an implied term that the party contracting will pay a reasonable charge. What is a reasonable charge is a question of fact. The same rule also operates in relation to goods by virtue of the similar provision contained in Section 8(2) and 3 of the Sale of Goods Act 1979. Whether there is a binding contract is based on an objective analysis of the behaviour of the parties, As in the case of RTS Flexible Systems Limited and Molkerai Alois Müller, the courts may take a step back from the contract and will examine whether there is a contract and a meeting of the minds.
That concludes the third episode of this series. Remember, if you're interested in learning more about contract law, please feel free to subscribe to this channel and to leave a like on this video to help others to find it as well. Thank you for watching, and I will see you in the next video where we will be discussing consideration